All right. Next file is State of Wisconsin versus Katrina Kitzman. Felony file 25 CF 1253. The defendant Katrina Kitzman is here in court with attorney Jennifer Kelly. Prosecutor is District Attorney Melinda Templis. Mr. Johnson, are you in on this case at all? Or
I am.
Yes, I believe
Alex,
Attorney Templis is taking it. Sorry about that.
okay. All right, we've got two things to do. One is first we'll address the bond request and we'll do arraignment after that. So on 2025 CF 1253, defense counsel filed a motion related to bond. I'll just double check and confirm the date. The DA's office did file a response. Motion was filed by Attorney Kelly December 3rd. It's document 18. I've read that a couple times. And then the state filed a response, which I've also reviewed a couple times. That was document 19 from District Attorney Templis, who's here. And that was the response. Later on, there was a state's discovery request and information filed. All right, I'm going to let Attorney Kelly elaborate on her motion, then we'll hear from the district attorney, and then we'll go from there. Go ahead, Ms. Kelly.
Thank you, Judge. Ms. Kitzman has been in custody since November 15th after this incident. She's 21 years old. She's a native of this area. She was born and raised here. She has significant ties here. She was employed for several years with AT&T. Her family is here. Both her brother and her father are here as support with her today. So those significant ties and frankly, no ties outside the state of Wisconsin. So I'd ask the court to consider that. But I do want the court to know just a little bit about Ms. Kitzman. This was an incident that is horrifying, that was terrible in so many levels, but this is not indicative of the woman that Ms. Kitzman is. This is somebody that was raised with trauma in a very chaotic household with parents who had their own issues. Her mother had some drug issues. This is somebody that was kicked out at 16 years old. And instead of letting that define her and failing, what she did is she worked so hard. She graduated early from Appleton West High School when she was just 17. She got an apartment. She got a job at AT&T. She worked there for several years. This was somebody that was responsible. This was somebody that was reliable and strong. And this situation was horrible. There's no question. But this is not indicative of her character and who she is. This was an anomaly. This was something that happened. We're still not even sure exactly what happened and why. But what she does know is that alcohol was involved. What she's done since then is, while she's in custody, is use that time productively and to good use. She's been doing the classes on the kiosk, everything from anger management to criminal thinking and everything in between. She became a trustee. They've already reduced her security level. She's also been doing AA. And that's one thing that's really important to her that she wants to continue to do. So Judge, right now, her bail's at $50,000, which is just absolutely exorbitant, nothing that she could even come close to paying. I understand these are serious charges, but there's nothing to suggest that she won't appear for future court appearances. She has absolutely no record, no priors whatsoever, not as a juvenile, not as an adult. This is somebody that has a bright future, and she's going to do everything she can to get it back on track and keep it that way. I understand these are serious charges. I think that perhaps CJTS check-ins to ensure her sobriety, even GPS, the bracelet monitoring, if the court thinks the community would be best served that way, to reduce any potential risk the court may be concerned about. But this is somebody that had a horrible situation, all kinds of regret, and wants to be able to focus on continuing to do AA, work on her sobriety, but be out there and be productive. She's not able to go back to AT&T. She lost her apartment. She lost her job. her car was impounded, but she is going to be able to work at where her father works. And it's Seagrave, which is the company in Clintonville. She'll also be able to get transportation with her father. She will be able to reside with him once she's released as well. So she will have that support. She'll have that transportation. She'll have the job and the productivity. So for all of those reasons, Judge, we do think that it would make sense. We think it's reasonable. We think it's appropriate for this court to reduce her bond. I don't know that she would be able to come up with more than even $3,000. That's a huge jump. I do realize that. But there's a lot to consider here. This is somebody that has absolutely no priors. This is somebody that's just not a threat, Judge, to the community. So we would ask the court to reduce it to about $3,000.
When you referenced Seagrave, that's out of Clintonville,
That's correct.
did they actually give your client a letter saying they're hiring her?
No, not yet. So that is not confirmed. She hasn't been actually hired yet, but my understanding is that is an opportunity that seems very likely.
Based on what?
Based on statements that I got from my client. Her father works there and has spoken, my understanding is has spoken to, I don't know exactly who, but people who would be in a position to do hiring, that she would be able to get a job there.
And if you had time to follow up on that with anybody in administration at Seagrave, that they're, there's legitimately going to be an offer of employment for Ms. Kitzman? If you had time to check on that?
I haven't, Judge.
All right. All right, we'll hear from the prosecutor. Go ahead.
Thank you. It's true. She does not have a prior criminal history. Sometimes that happens where we don't have that. She's still pretty young, but to say that she's not a threat to the community is not how this reads at all. She was intoxicated. She had THC on her person. And quite frankly, she could easily have killed the officer who responded, who's present today. She could have injured him even more than she did, could have killed him, could have killed somebody else because she was driving at high rates of speed between the St. Joseph's parking lot, Oneida and Glendale, drove over railroad tracks, was driving with no lights, was completely out of control and driving all over very populated areas of town where there's a lot of different people, almost hit other people in the parking lot. As well as others, almost hit another officer in addition to the officer that she did hit. So I understand she doesn't have priors. I understand the request for the bond modification. I do still have community safety concerns about her sobriety, about her use, about what she'll do when she is out to not put somebody at risk of what happened on this particular night again. The idea of we don't know what happened or why, well, the why is because she was drinking and using drugs, and what happened is outlined in the criminal complaint as the allegations. They're on body cam. Much of it is on body cam. And obviously there is a significant community safety component to the fact that it is the holidays and it's a time when a lot of people like to enjoy a drink or more than one drink. And that's kind of where this started. So the state still has significant community safety concerns. I know that the officer who's the victim in the case is present, does not wish to make a statement, but just does believe that bond is appropriate when it was set. So at this point, the state doesn't have anything further.
I don't know if you were given a heads up on it, but did your office check with Seagrave to see if there's even an offer, or that's the first time you're hearing about it today?
I just heard about that. I don't know anything about Seagrave. I don't think it was in the bond notice, and I wouldn't have otherwise known.
I just found out this morning.
Pardon me?
I just found out this morning.
All right. All right, well, stable employment in the community is important for the court to consider as a reinforcement of ties to the community, not just the existence of living here for the last 20 or 21 years or so. Ms. Kitzman, the bond statute has the court weigh a number of things, including appearance in court, the risk to the community issue is more relevant in the last few years since the bond statute was changed. So that's important. On the issue of community safety, Ms. Templis, beyond drugs in the car, was there any kind of weapon? I thought there might have been some reference to that, or no?
Let me double check. I don't think I remember a weapon.
All right, on the bottom of page
It was in
8.
there was a crossbow and a shotgun, but I think it was in the back of the vehicle. Not one that I charged, though.
All right. The last few paragraphs on page 8 reference Officer Thor removing.
Yes.
You know who the 12 gauge was registered to, or it doesn't?
I don't.
Okay.
And Judge, I do believe she has a hunting license as
All
well.
right. Do you have a test back yet?
No.
All right. All right, and the PBT has limited value, but at least the PT says 0.218, which heightens the risk factors. Sometimes we get cases where people are on bond and they commit a new offense. The defendant wasn't on bond, but in some aspect, just the awareness of multiple officers, and there's, at least in the charging sections, there's multiple officers listed, Officer Reeder, and then Officer Allen, who's here in court. The court would say a couple things. I double checked the defendant history is described by her lawyer as limited, so that's an aspect that the court puts weight on. The incident itself on the 15th, I'm not putting it in the category completely of like an OWI homicide, but over the years in the court system here, last at least 36 plus years for me, we do get cases where sometimes it's a first offender that commits a OWI homicide or something close to that. And even with a lack of prior record, there's still the magnitude of the charge or charges and the public safety issue. So our legislature, at least in the last few years, has highlighted that it's not just ensuring somebody's appearance in court, but who's put at risk, not just the two officers mentioned in the complaint, or there's more than two, but at least in the charging sections, there's two different officers mentioned. So the court puts weight on that, not just their safety, but the public safety. And although it's not a situation where a defendant was on bond and violated rules of bond, at least the context of it's explained, within a couple blocks of here, right across from the police department, is a defendant who has eyes on the people around her, whether it's the citizens that were trying to address the behavior and calm the situation, but then the officers in uniform. So sure, she didn't have a bond sheet in her car and was aware of her conditions. It wasn't that context, but when you have multiple officers right in front of you, beyond the citizens that are trying to address the situation, it's law enforcement in their uniforms trying to address a public safety issue. And then there's direct actions alleged towards the officers and then back out in the community until stopped. So there's a high degree of public safety that's and concern for the public safety that's explained. I understand the context is not like in the middle of the day when everybody's hope to be sober and alert and focusing on their daily work activities. It's something that is alleged to have happened in the middle of the night, soon after bar time, but the overall context is extreme on the safety levels.